right, so
We're on the record.
we're back on the record in the matter of Norcutt v. Council, and everybody is present. So we are here for today the decision of the court, and also Mr. Council was given the opportunity to respond to the documents that were filed by Mr. Page, and that is specifically, we'll go through them. Okay, since the last time we were here in court, well, not the last time, I think there was another hearing briefly, but on July 14th, 2021, Mr. Page had filed some documentation, and Mr. Norcutt indicated that he had not received them. He requested some time, so he's now had the time to review them and respond to them. And Mr. Page updated the schedule of arrears, and the only document that Mr. Council submitted was on August 10th, 2021, and it says exhibits Harriman from Mr. Page and Norcutt. I'm guessing it's just a typo, and he intended to call it harassment, but is that correct, Mr.?
Yeah, I apologize. Yes,
It's okay.
I filed my
Okay.
doctor's note.
Oh, yeah, I saw what you filed, sir. It looks like you filed something today. I can't see it. It hasn't come through. So
That was just my receipts on all the child support payments that I have made for 2021.
okay. So in the document that Mr. Council submitted on August 10th, 2021, it consisted of, it looked like emails between Mr. Council and Mr. Page.
Correct.
And then attached to that, so I don't think that any of the emails were relevant, and certainly not in response to the documents that Mr. Page filed, with the exception,
Your Honor.
excuse me, Mr. Counsel, that with the exception of there was a payment receipt and a payment confirmation. So Mr. Page had submitted a document called Plaintiff's Declaration in Support of and Schedule of Child Support Arrears for Gage Council, and that was it was revised from the earlier filing, because the earlier filing it included penalties that were changed by law on February 1st, 2020. So the corrected version was filed on July 21st. And it looks like it is...
He's vaping.
Yeah, Mr. Gage, excuse me, Mr. Counsel, we're in court. So vaping is inappropriate, sir?
I'm sorry.
So, the child support arrears, well, I will get to that shortly. I will get to that shortly. I'm going to try and take this in logical order, which is going to be difficult. So, the pending issues after, I'm gonna strike that. Okay. This case was initiated by the filing of Mr. council's motion on January 22nd, 2019. It was a motion to enforce the order from evidentiary hearing entered herein on October 11, 2018, to modify custody, to enforce the decree of divorce filed on October 10, 2016, for an order to show cause and for other relief. Ms. Norcutt's opposition to the motion was filed. And she also filed a motion for division of omitted debt for an order to show cause to compel defendant to provide his 2018 W-2 for defendant to pay child support, to modify child support going forward, to set aside the prior child support order for fraud, and modify child support retroactively and for related relief. And Mr. Counsel then filed an opposition on July 8th, 2019. It was an opposition to plaintiff's motion and a counter motion to continue the evidentiary hearing to suspend defendant's child support obligation for the minor child to be enrolled in Clark County School District for the 2019-2020 school year and for attorney's fees and costs. And then plaintiff filed her reply on July 15, 2019. This case was originally before the Honorable Cheryl Moss, and Judge Moss conducted the evidentiary hearing that began day 1 was November 19th, 2019. Day 2 was January 23rd, 2020. Day 3 was February 28th, 2020. And soon after that, COVID hit, and the rest of the evidentiary hearing was not able to be conducted prior to this court reassigning this case to Department Z before me. And so this court resumed the evidentiary hearing on day 4, June 16, 2021, and day 5, June 17, 2021. So to bring myself up to speed, I obtained all of Judge Moss's very detailed and meticulous notes. There are multiple pages of single-spaced notes that she made and provided me with, and in fact it consists of 1, 2, 3, 4, 5, 6, 7, 8, 9 and a half pages of single-spaced notes that are very detailed, and it identifies each day of trial and which what part of the trial was conducted that day. For example, she has a section called Direct of the Guardian Ad Litem, Shelley Cooley, by mom's attorney, and then she has the significant notes there, and then cross-examination by dad, notes there, and then redirect, and then she goes to the direct of Philip Caldwell, and etc. throughout the first 3 days of the trial. So I have carefully read her notes, and I also obtained an informal transcript of all 3 days of those hearings through voice recorder transcript, and I read through all of those, and I matched up I matched up Judge Moss's notes, because she numbered them from statement number 1 of the testimony through statement 236. So she has 236 separate statements that she derived from the testimony. There are a few in here that are blank, but not very many. And so I matched up the 236 statements that she identified in her notes to the location where I found them in the informal transcript, and matched them up so that I could get a very clear indication of the testimony. And as I stated previously today on the record, I believe approximately 99% of the testimony that was obtained during the evidentiary hearing on those 3 days was related to custody issues. And at the beginning of the evidentiary hearing before me on June 16, 2021, Mr. Counsel stated on the record that he was withdrawing his request for a change in custody, and he was going to allow the minor child, Gage, to remain in the primary physical custody of his mother, plaintiff herein, in Washington. So therefore, the only issues that were remaining, and we discussed this on the record to make sure that this court was very clear of the issues that remained before the court, based on the relief that was requested of the parties, and the pending issues remained that defendant dad sought or seeks the following orders. 1A, an offset for child support arrears in the approximate amount of $2,000. Thus, mom would pay dad $4,000, or in the alternative, mom would pay dad approximately $6,000 pursuant to the provision in the decree of divorce. And the provision that this specifically addresses is contained in the decree of divorce, and it is on page 13 of the decree of divorce, lines 8 through 11, and it states that Alex shall assume sole and separate responsibility for the parties' consumer debts, and shall indemnify Goldie therefrom. To equalize Alex's assuming such debt, Goldie shall pay to Alex the sum of $250 per month for a period of 24 months. However, on June 5th, 2018, Judge Moss held a hearing, and in the minutes of that hearing, it states, credit card debt. There was a $6,000 debt that Dad has not complied with as part of the decree of divorce, as part of their equalization. Mom at the time agreed to pay her half share and pay Dad. However, Dad never paid his portion. Mom is no longer responsible to pay that obligation to Dad. Court finds Dad failed to pay the credit card debt. Now, Mr. Page, I have been unable to locate the written order that contains that provision in it. Do you have any idea where the written order is that corroborates that finding an order in the minutes from that hearing date of June 5th, 2018?
I am unable to find an order. That's why I couched it in the hearing or the trial as being in the minutes. I've conducted my own search. I was unable to find anything similar. However, it is in the minutes. It certainly should be enforceable because that is what the judge ordered, even though we don't have a writing. We don't have the item reduced to a writing and filed with the court as an order.
I agree. Therefore, Mr. Page, would you please prepare an order nunc pro tunc with containing that provision.
Yes.
Okay, thank you. So therefore, inasmuch as the court already previously ordered that mom is no longer responsible to pay that obligation to dad, because the court already made a finding that dad failed to pay the credit card debt, this court is compelled to follow the Judge Moss's previous order, and so therefore this court denies dad's requests
Yep.
as the items that I as item 1 of the relief.
Your Honor,
debt.
Your Honor, real quick, my portion of the credit card debt was paid. I addressed that with Judge Moss. I don't recall if that was the date there was a sub-judge in there or not. However, I don't have a written order with that, and I believe I would like to go back and watch the video transcripts from that date, because my memory and my notes clearly state that Miss Moss,
Judge Moss.
Judge Moss, I'm sorry, was, incorrect, because my portion was paid.
Okay, well,
And I don't have a counsel representing myself, and I believe I turned all that in with all of my exhibits.
Okay, well, you didn't bring that out in this evidentiary hearing, and Mr. Page did address that.
I did, Your Honor.
No,
I've addressed this since day one.
No, you did not. I don't have any notes indicating that you refuted Mr. Page's statements and and evidence that he put on during the evidentiary hearing. So, Mr. Counsel, what you can do is you can certainly file a motion after you review the hearing video, and if you find that that was incorrect, then bring the motion. But for the time,
You got it. Thank you.
For the time being, that request for relief is denied. So,
Understood.
Defendant Dad's second request for relief was the temporary reduction in child support, and I have a competing request from plaintiff mom asking the court to modify or increase the child support retroactively to August 2018. However, EDCR EDCR 5.507 provides that financial disclosure required for motions involving money, unless otherwise ordered by the court or otherwise required by another rule or statute. It states that subsection A states that a general financial disclosure form must be filed in support of any motion or counter motion that includes a request to establish or modify child support, spousal support, fees and allowances, exclusive possession of a residence, or any matter involving money to be paid by a party. And a financial disclosure form must be filed within 3 days of the filing of the motion, counter motion, or opposition it supports, and may only be filed in open court with leave of the judge upon a showing of excusable delay. So, inasmuch as the last version of a financial disclosure form that Mr. Counsel has filed with this court was on January 22nd of 2019, which I might add represents that he is occupied as a purchasing manager, earning gross monthly income in the amount of $6,000, which is inconsistent with his testimony that he has been unemployed. The court is compelled to deny defendant's request for relief for temporary reduction in child support and defendant's request for attorney's fees. Plaintiff mom seeks the following orders. Number 1, order to show cause regarding dad's failure to pay 509 payments. Number 2, to modify or increase child support retroactively to August 2018. And number 3, attorney's fees. Starting with item number 1, the order to show cause regarding dad's failure to pay 509 payments.
Your Honor, can I speak, or are we listening at this point?
You're listening at this
I'm
point.
sorry. Understood.
The court has to deny the request for the order to show cause for contempt because pursuant to EDCR 5.510, a motion seeking an order to show cause for contempt must be accompanied by a detailed affidavit complying with NRS 22.030 subsection 2. And in this case, the court did not receive a detailed affidavit pursuant to EDCR rule 5.510. Plus, I don't see that an order to show cause was ever actually issued prior to the evidentiary hearing.
Actually, it was, Your Honor.
Nonetheless, I can enforce the terms of the decree of divorce. And under the terms of the decree of divorce, it states as follows.
While you're looking it up, Your Honor, there was an order to show cause filed on August 19 of 2019 that addresses the failure to pay child support and his failure to timely provide his W-2. And it was set for the 16th of November.
Your Honor, he's speaking, and I can't talk.
Mr. Counsel, you're interrupting. You know we don't do that in here. Go ahead, Mr. Page.
The order to show cause was set for November 16, 2019, the first day of the evidentiary hearing. That order to show cause has been continued on every day since. So the judge at the hearing concluded the affidavit was sufficient and issued the order to show cause, which he signed and was filed with the court on, I believe it was the 19th of August 2019.
Well,
August 21.
you are absolutely correct, Mr. Page. I am looking at it now. I did not see it previously. So thank you for pointing that out to me. The court did issue an order to show cause, and that was filed on August 21st, 2019. And it does indeed state that Mr. Counsel shall appear to determine why he should not be held in contempt for his failure to timely provide his W-2 and be punished according to law, therefore, including fine, imprisonment, or both. In the order from August 2018 on page 14, lines 1 through 4, requires the parties to exchange their W-2s. The order stated, it is further ordered that on March 1st of every year, the parties shall exchange their redacted W-2s and all income from any sources until further order from the court. It is further ordered that defendant Alex Counsel shall appear on the blank date to determine why he should not be held in contempt for his failure to timely pay child support and be punished according to law, therefore, including fine, imprisonment, or both. The order from the August, this seems to be a typo, from the August required defendant Alex Counsel that, quote, well, this is all a quote, Dad shall pay $200 as and for the support of the children. Effective October 1, 2019, Dad shall pay $100 of the support into a blocked account or a 509 educational plan for Gavin's designated college fund for a total contribution of $10,000, with the condition that Gavin be enrolled in college. Effective September 1, 2018, Dad shall pay Mom $100 to be direct deposited into her bank account with a 5-day grace period. Mom shall provide her account number by September 1, 2018 through Our Family Wizard. So that is correct. So, thank you, Mr. Page. So the court...
Your Honor, real quick in regards to that, if you don't mind, the minutes from August 7th, I was going to point out, but you already stated it. So that the condition that Gavin be enrolled at college, and I never received any documentation or any proof or any school records that he was even in college. And I've asked multiple times what college he's in, how's his grades,
Mr.
and I
Counsel?
get no response.
Mr. Counsel?
Yes, Your Honor.
I'm getting
Yes.
to that. I'm getting to that.
Okay.
Yeah.
I'm sorry.
No worries. You didn't know. I'm getting to that, though.
And I also submitted my W-2s. I did provide them in my exhibits, so he was incorrect.
No, actually, no. You were incorrect, sir, because there was testimony, and I'm getting to that as well.
Okay.
The
7519.
let's see, my
7519.
Miss, stand by, please.
I'm mute.
Thank you. I appreciate that. Thank you. Okay, so I am going to grant the order to show cause. Well, it was already granted, but I am going to make a finding that defendant is in contempt of court for his failure to pay the 509 payments as required in the order filed October 11, 2018 on page 12, lines 8 through 14, and also on page 12, lines 17 through 19, on page 6, line 24 through page 7, line 2, and the order states that Dad shall pay $200 as and for the support of the children effective October 1st, 2018. He shall pay $100 for the support into the blocked account of 529. Have I been saying 509? 529. If I've been, is it 509 or 529? Now
I thought it was 509.
I've got two.
It's a typo in there.
I'm sorry?
It's a 529 account. It's a typo.
Oh, thank you. Okay. 529. Sometimes I'm calling it 529. Sometimes it says 509. So 529 account. All right. So there is a condition on this order that was just raised by Mr. Counsel. The condition being that Gavin be enrolled in college. Mr. Counsel's argument is that he was never told whether or not Gavin was enrolled in college, but that defense is irrelevant because the language of the order clearly states that the condition to trigger the obligation of Mr. Counsel to perform was not it was not conditioned on whether or not knowledge was provided to Mr. Counsel. So if Mr. Counsel had any concerns that of whether or not he was obligated to make such payments, he had the duty and obligation to seek that information, but it is irrelevant whether or not he had knowledge of it. Reading the clear language of the court's order, the condition was triggered by Gavin's being enrolled in college. Now, I have a question for Mr. Page. In the document that you filed on July 21st, 2021, which is the schedule of child support arrears for Gage Council, you excuse me, no, not that one, the other one, the Gavin Council one, that was also filed on July 21st, 2021. I noticed that you only provided, you only included payments from October 1st, 2018 through June 1st of 2019. I can speculate that what you are saying is that Gavin was only enrolled in college for those periods of time from October 1st, 2018 through June 1st of 2019. Is that why those are the only payments that you've included in that spreadsheet?
No, it was a safe harbor. As you can see in the order, it was labeled as child support to Gavin to fund the 5229 account. Gavin aged out. He graduated from high school in June of 2019. So in a worst-case scenario, Mr. Counsel would be obligated for that time period. He could argue, I suppose, and Your Honor, it's an open interpretation, that anything after June 19 couldn't be bound by because child support ends as a matter of law when he graduates. June of the year he graduates from high school if he's under the age of 19. The safe harbor is why we did it the way we did it. He did go to college and he is in college.
I'm sorry?
However, just because it's labeled as child support, that's it.
Okay, you cut out on a lot of that, so I'm not sure I completely understand. So you're saying that Gavin was still enrolled in high school and was under the age of 18?
Through the end of June 2019, that is correct.
Okay, so that's why you included the $100 payments there.
Yes.
Okay.
After that point, because it's labeled as child support, the safe harbor to at least have Alex be held in contempt for something would be to cut off the arrears at that point.
Mr. Counsel, where did you go?
Oh, I'm sorry, I dropped my pen.
Oh, okay. And the video is
Sorry.
jumpy, so all of a sudden you weren't there, and all of a sudden you magically were. Okay. So say that last part again, Mr. Page, that very last sentence.
It was a safe harbor to make sure that Mr. Counsel was held in contempt for something because of the label in the order of child support. It could be argued, in my opinion, that the obligation automatically cut off upon Gavin emancipating as a matter of statute.
Okay, so what you're saying is you're not going to try to hold him in contempt for failure to pay into the 529 account? Is that what you're saying?
No, I am trying to have him be held in contempt for his failure to pay into the 529 account. What I'm trying to do is make sure he's actually held in contempt for something by doing this the safest way I possibly can on behalf of my client. I don't want to have an argument that he can't be held in contempt for something after June of 2019 because Gavin emancipated.
Your Honor, it's with the condition that he be enrolled in college. That would have gladly been taken care of. However, I had no knowledge or any proof or any claim
Ms.
that he went to college.
Sorry.
Ms. Norcutt, mute your mic, please.
Okay, sorry.
Mr. Counsel, I've already addressed that.
Yes.
There's not a notice provision included in this language.
I don't understand what that means.
Excuse me, in my opinion, it's poorly worded to your detriment, but in any event, I think to err on the side of caution for you to not be held in contempt, you should have made the payments. You shouldn't have erred on the side of caution by failing to make the payments and then making this weak argument later. So,
Your Honor, I sent numerous of messages
Mr.
to Mrs.
Counsel,
Norcutt.
you've
Hey,
told me that repeatedly. I understand, and it's irrelevant. My order stands. So, so it looks like Mr. Counsel did not make any payments. Well, if the child was in, see, and this like puts a whole nother spin on it. I didn't realize that the child was, you probably told me, but I didn't realize that the child was still enrolled in high school through June of 2018. So
19.
19. To June. Okay.
I don't know how that's possible.
So
He's supposed to start college. Sorry, I'm mute.
so he's supposed to pay $100 for support into a blocked account with the condition that he be enrolled in college. I don't see how he could. How could the condition exist that he be enrolled in college while he's still in high school? That doesn't make sense to me. I did not realize that he was still in high school when this child support obligation was to trigger.
I don't think that his obligation is going to be contingent upon the duty of responsibility for Gavin to be in college. I think it has to do with that he has a duty to support his child, and it was going to be the idea that he would pay $100 per month with the more aspirational goal that Gavin would be enrolled in college at some point. The fact of the matter remains is he never made the first single payment even while Gavin was in high school, even though it was labeled as child support.
Yeah, well, he does. He certainly does. The law does require him to pay child support. And
Your Honor, I was making.
Excuse me, Mr. Counsel. Really, I'm going to give you an opportunity to speak. If you afraid that you're not going to remember what to say, write it down. But don't interrupt me. So the payment, the obligation for payment of $100 a month for the support of, well, it's poorly worded, but it says that Dad shall pay $100 for the support into a blocked account of a 529 educational plan with the condition that Gavin be enrolled in college. Well, I see what you're saying, Mr. Page. I do agree that he has an obligation to pay child support for Gavin up until the statutory time, when which apparently was June 2019. So I see what you're saying. So I do agree with that child support amount that you have provided, and all of that occurred prior to the law changing with respect to the calculation of child support in Nevada. So therefore the court finds that Mr. Counsel failed to pay $100 a month under his obligation to pay child support, both statutorily and pursuant to the decree court order from October 1st, 2018 through June 1st, 2019, and based on the schedule of arrearages that was filed on July 21st, 2021, the total principal amount due as of July 21st, 2021 was $900. The total interest due as of July 21st, 2021 is $141.74. The total penalty due as of July 21st, 2021 was $222.24. Therefore, the amount due, if paid on July 21st, 2021, was in the amount of $1,263.98. The amount due, if paid on July 22, 2021, was $1,264.36. So that amount is reduced to judgment, collectible by all lawful means. So now you did not provide a schedule of arrearages for the 529 payments, correct, Mr. Page?
After June 1, we did not. I did not do so because it was labeled as child support. And that circles back to my interpretation, or at least my safe interpretation of the statute, that child support ceases once Gavin emancipates.
Okay. However, what about the fact that wasn't this a stipulated term in the decree?
It was stipulated. I agree.
So then it would be a contractual obligation, would it not?
One could argue that. That certainly did cross my mind. However, I stuck with the safe harbor aspect of it. I mean, I can certainly bring it up again and try and have those contractual terms be enforced. But I was looking to make sure that I could get the orders that were most easily obtainable in my mind.
Well, I think it's not very clear to me in the language of this. Well, it all says stipulated decree of divorce. And that
This was actually the evidentiary hearing, so that wouldn't be necessarily stipulated for in the decree of divorce. It was after the last day of the August 7, I believe it was, 2018 evidentiary hearing.
Yes, you're right again. So it was in the order modifying child custody, allowing plaintiff leave to relocate to Washington, that was entered October 11th, 2018. That's where that provision appears. So, was that stipulated? Because you said that it was, but
Let me take a look here on what I have online.
yeah, it says, I'm looking at the language of the order entered October 11, 2018, and it says, this matter coming before the court on August 7, 2018 for day 5 of the evidentiary hearing. Oh, okay, yes, it was stipulated. I'm looking at page 2 of that same order. It says, at such time the matter was trailed for settlement discussion and then recalled, at which time the court was advised that this matter had been globally resolved by the parties. The terms of the global resolution were then placed on the record. The parties have reached a stipulated agreement resolving all outstanding issues related to this case, including but not necessarily limited to modification of child custody, relocation of minor children, child support and visitation, And so yes, these terms were stipulated. So I believe that under a theory, a contractual obligation would apply.
Okay. We can address that on another day then,
Well,
quite easily.
well, I just think that we need the schedule then to support that.
We can do that.
Okay, so that is. Let me go through my findings too. Well, let me just go ahead and continue on here. And then Mom also asked the court to modify child support retroactively to August 2018. And I'm reading my handwritten notes here. The stipulation for Dad to pay $100 a month towards a 529 account. Oh yeah, was there, I had a question to myself, was there ever any evidence that Gavin was going to college other than Mom's testimony? There's no requirement in the October 11, 2018 order that Mom provide evidence that Gavin was in college, but there's a condition that he be enrolled. I noted from Judge Moss's notes that Mom testified strike that. That's what I was trying to get at. In Judge Moss's notes, she indicated that Exhibit 6 was Gavin's college acceptance letter, but that was never offered or admitted into evidence, so I don't have it. It's actually already been pulled from the exhibits that were provided to this court. So I don't have that. All I have is Mom's testimony that Gavin was enrolled in college, but there was no indication of how long he was enrolled in college. So I don't know how long he was enrolled in college. So since
it was in my exhibits.
All right, but I also think Gavin testified to that one on the end.
He testified and I submitted his student loan too.
I do have in Judge Moss's notes that he did testify that he's in college studying visual arts and film as a major freshman. So I only have evidence that he was enrolled for one semester.
I think the way the order is written is kind of Mr. Counsel's burden to show that Alex wasn't, or Gavin wasn't enrolled.
I object it the other way.
I don't. I mean, you can
I have no
elaborate.
proof.
You can elaborate on that argument, Mr. Page, but I don't see that. You can try and point it out to me. I don't see it that way.
Well, we have what we have through the end of June, or end of beginning of June 2019. The rest we can address it in another time in another way.
So this testimony of Gage, this was on the first day, on November 19th, 2019. So it looks like, and he was a freshman. So we have. I'm willing to order that Mr. Counsel pay for one semester of college, unless you can show me where there was evidence that he was enrolled in more than one semester in college, because we have Mom's testimony that he was enrolled in college, and we have Gavin's testimony that he was enrolled in college, but I don't remember seeing any other evidence of that. So if you can point that out to me, I'll let you do that, but I'm willing to...
I can get all of the documentation.
No, it's too late for that.
Okay.
Your Honor, we're putting the cart before the horse. We were never arguing, as you can see by the schedule of arrears, as to Gavin being, we weren't seeking anything beyond June 19 for unpaid child support. We never presented that to the court. That was never part of the evidence that we presented. So to say that we're looking for everything from, say, July 2019 through to the present, it was never before the court because we never litigated before the court. The only thing that we litigated was through June of 2019. Anything else is still unadjudicated and ripe for a further motion.
Okay. Well, I can agree to that then, because I don't have any evidence beyond that. I only have, as you said, the schedule of arrears through June of 2019. So, all right, we'll go with that. Thank you, Mr. Page. That makes it a little bit easier.
Thank you.
Okay, and so then there was the request for Mom to modify, increase retroactively the child support to August 2018. And Mr. Page presented credible evidence of Dad's employment during the period of time that Dad testified that he was unemployed. Dad had testified that he had been unemployed since August of 2019. No, 19? Gosh, I'm trying to find my notes here. let's see, he started working July 30, 2018, and filed a financial disclosure form on January 22nd, 2019, that he was earning $6,000 a month. So that was during the time of the previous child support calculation statutes, and therefore he should have been paying I did not do the calculation for that. I know it was argued that he should have been paying $800 a month effective August 1st, 2018 through the present. But I did not do that calculation to confirm. It was 18%, wasn't it? Then there was a presumptive maximum amount. Let's see.
Are you there? Yeah.
So you're saying that so the 18% of $6,000 gross monthly income would have been $1,080 a month, but I imagine
Subject to
because you
the
argued,
caps.
yeah, because you argued that he should have been paying $800 a month, that he should have been paying that was the presumptive maximum amount.
Right.
Okay.
The cap for that period would have been $781.
I'm sorry?
The cap for that period would have been $781 per month.
Oh, okay, thank you. $781 per month, and that was effective August 1st of 2018 through the present. And I did take a look at the schedule of arrears for Gage, for payment of child support for Gage Council, and I believe it's accurate. Mr. Page made the calculation starting September 1st, 2018, in accordance with the court's order, and he made the payments $100 a month until the court changed its child support order, and the obligation was, after August 1st of 2019, was $500 per month, and utilizing the Nevada Child Support Enforcement Payment Record that was produced by Mr. Counsel during the trial, and it was, this payment record was as of June 8th, 2021. Mr. Page correctly credited Mr. Counsel for every payment that was shown on the Nevada Child Support Enforcement Payment Record that was admitted into evidence as Defense Exhibit L. And so that yielded a total principal amount due as of July 21st, 2021, in the amount of $5,131.60, with the total interest due in the amount of July 21st, 2021, in the amount of $468.23, and total penalty due as of July 21st, 2021 in the amount of $249.38. And so the total amount due if paid on July